The bench is on the south side of Mercer Street, under a parking structure overhang that keeps the rain off until the wind shifts, which it does at approximately 3 in the morning, and Daniel Avery has learned, in the 14 months he has been sleeping on or near this bench, to wake at 2:45 and move to the alcove behind the CVS that closes at midnight, which is windproof but smells of the dumpster beside it, and to make this calculation without thinking about it the same way he once made calculations about discovery deadlines and deposition schedules. Automatically, in the background, the professional management of adverse conditions. He is 44 years old. He was, until 22 months ago, a partner at Callaway Mercer Ellis, one of the 7 largest litigation firms in Chicago, a position he had earned across 16 years of a career built on the specific combination of intellectual ferocity and strategic patience that makes a trial lawyer genuinely dangerous rather than merely competent. He owned a house in Lincoln Park. He had a daughter, Zoe, 9 years old, who on Saturdays he took to the Art Institute and who always wanted to spend the longest time in the Impressionist rooms, and who had a specific opinion, for 9 years old, about Syrah that she was not shy about sharing. He sees Zoe every other Saturday now, at the McDonald's on Wabash, because it is warm and his former wife Caitlin brings Zoe there. It does not make either of them perform a normalcy they don't feel. These meetings last 2 hours. They're the fixed point around which he organizes everything else. The everything else is this: a duffel bag with a change of clothes, a waterproof case containing a laptop with 11 hours of battery life, and a cellular modem he pays for with a prepaid card, a legal pad, and a file. Not a physical file, because physical files can be taken, but a mental file, cross-referenced and updated daily, with the specific, exhaustive precision of a man who spent 16 years building cases for a living and who has been, for 22 months, building the most important case of his career. The case is against the people who did this to him. He has been building it in the evenings on his bench, and in the alcove, and in the public libraries whose warmth he has mapped with the same systematic attention he once applied to courtrooms. He has been building it the way he built every case, from the first principle that the work has to be right before it can be useful, that the foundation has to be unassailable before the argument can stand on it, that being right and being provable are 2 different conditions, and the condition that matters is the second one. He has been building it with the knowledge that it may take longer than he has, and with the decision, made on the 4th day after his disbarment, when the shock metabolized into something useful, that the length of time required is not a reason to stop. The disbarment proceeding against Daniel Avery was, in the public record, a clean story. A partner at a major litigation firm had been found in possession of fabricated evidence in the Harmon Financial Services matter, a civil fraud case involving $340 million in client assets. The fabricated evidence, specifically a series of internal communications bearing the signatures of Harmon's CFO that were later determined to be fraudulent, had been submitted to the court in a pretrial filing under Daniel's name. The state bar's investigation found clear and convincing evidence of professional misconduct. His license was suspended. Callaway Mercer Ellis terminated his partnership. Caitlin filed for divorce 6 weeks later. The private story, which Daniel has been assembling across 22 months from sources that become accessible only to someone who has lost everything and therefore has nothing left to protect in the calculations people make about what information is worth their professional risk. The private story is different. The Harmon Financial Services case was not primarily a civil fraud matter. It was, underneath the civil fraud matter, a piece of a larger landscape, Harmon Financial Services had, across 11 years, processed what Daniel's investigation has concluded was somewhere between $2 and $4 billion in transactions for entities connected to a network of public officials and private interests whose specific interconnection Daniel has spent 22 months mapping. The fabricated evidence was not fabricated to win the case. It was fabricated to end the investigation. Specifically, to remove the one attorney who had gotten close enough to the underlying transaction structure to see what it actually was. What 22 months on Chicago's streets teaches a person who is trained to notice things and build arguments is not what Daniel expected to learn, which is that what it teaches you in the specific, unglamorous, mandatory curriculum of survival is how systems actually function as opposed to how they present themselves to the people they were designed to serve. He had known, as a partner at Callaway Mercer Ellis, that the legal system was imperfect. He had known it the way that a person who has spent their professional life operating inside a large and complex institution knows all the institution's failures, specifically, thoroughly, and with the specific professional distance that comes from being, in the main, on the institution's cooperative side. What the street teaches is the view from outside the cooperative side entirely. He learned that the Cook County Public Defender's Office handles an average of 500 cases per attorney per year, which works out to approximately 21 minutes of attorney time per case per year, a number that Daniel had never fully inhabited as a fact until he watched it operating from the outside. He helped sometimes, not formally. He had no license. But the knowledge of how courts worked and documents were filed and deadlines operated did not leave him when a license did. And there were people whose situations required someone who understood procedure and who had, before coming to them, no access to someone who did. He did not help them because it was strategic, although it eventually became so. He helped them because he was a lawyer and there were people who needed help with legal things, and he was there. The file exists in 3 places: on the laptop's encrypted drive, in the legal pad whose pages Daniel photographs every 2 weeks and stores on a cloud server accessible through a VPN, and in his memory, which retains not just facts, but the specific relational structure between facts, the web of connection that makes individual pieces of information into something that can be argued rather than merely asserted. He built it beginning on the 4th day after his disbarment. He started with what he knew, the Harmon Financial Services case file, which he had memorized across months of preparation. He built outward from there, using public records, SEC filings, court records, property registrations, corporate dissolution and formation records, which are, in aggregate, a remarkably complete account of institutional behavior for people who know what to look for. He cross-referenced across 14 months of daily work at public libraries, building an architecture of connection whose individual elements were each individually defensible in a legal proceeding and whose collective shape was unmistakable. What he found 14 months in was a name that, when he followed his connections through 14 months of public record research, connected to 3 Cook County judges, a state's attorney, 2 members of the city council, and the specific final piece he spent 2 more months verifying from 4 independent sources, the managing partner of Callaway Mercer Ellis. His former firm, the firm that had terminated him, the firm whose managing partner had not terminated him because of the disbarment proceeding, had terminated him because the disbarment proceeding had been arranged in consultation with a managing partner. He sat in a library on State Street for a long time after he understood this. Then he opened the legal pad and wrote, at the top of a new page, People v. The system that buried me. Argument. The specific problem with the most complete case file Daniel Avery has ever built is that it is assembled by a disbarred, homeless former attorney with no professional standing, no institutional affiliation, and no pathway to filing anything that anyone is required to take seriously. He knows what he needs: a licensed attorney with federal practice credentials, with no connection to the Cook County network he has mapped, with the specific professional courage to file an action that will make them a target of the same network until the action either succeeds or fails decisively. He has been watching Maya Chun for 6 months. Maya Chun is 38, a federal public defender who has been with the Northern District of Illinois office for 11 years, who has a conviction rate, the wrong metric for a public defender, which is why Daniel uses the metric nobody applies, the rate at which her clients receive sentences below the federal guidelines range of 63%. She takes the lunch hour at a soup kitchen 3 blocks from the federal building. He approaches her on a Tuesday in March. "Ms. Chun, my name is Daniel Avery. I was a partner at Callaway Mercer Ellis until 22 months ago when I was disbarred on fabricated evidence. I've spent 22 months building a federal RICO case against the network responsible. I'd like you to read it." Maya Chun looks at him. She does not stop eating. "Who fabricated the evidence?" "The managing partner of my former firm, in coordination with 3 sitting Cook County judges, a state's attorney, and 2 city council members, all connected to an 11-year financial fraud operation involving somewhere between $2 and $4 billion. "You're the guy from the Harmon case," she says. "Yes, I followed that disbarment. Something about it didn't sit right." "I know. That's why I've been watching you." She puts down her fork. "How long have you been watching me?" 6 months. "That's a lot of soup kitchen lunches." "I eat here anyway," Daniel says. "I'm homeless." Maya Chun looks at him with the specific look of someone recalibrating their assessment of a conversation in real time. "Sit down," she says. "Tell me what you have." What Maya Chun does after Daniel has talked for 40 minutes and she has asked 23 questions that are specific and good is say, "I need to see the file." She reads for 3 hours and 40 minutes. When she finishes, she does not say anything for 90 seconds. "You built this from public records." "And memory," Daniel says. "The Harmon case file, which I had memorized before the disbarment. Your memory of a case file you can't produce. I can reconstruct it with sufficient specificity that the reconstructed version, verified against what the Harmon court has in its own record, will demonstrate its accuracy. There are 47 specific factual claims in the memory reconstruction that I've verified against public court records. Each one holds." Maya is quiet again. "The RICO theory. Walk me through it." He walks her through it. An hour. She interrupts 14 times with questions that are increasingly the questions of someone building a case rather than someone deciding whether to build one. When he finishes, the managing partner, "You're saying he knew about the fabricated evidence before it was submitted." "I'm saying he arranged for it to be fabricated." "A financial relationship that makes him a principal in the conspiracy rather than a beneficiary of it." "Yes, that's the jurisdictional hook," Maya says. "The federal RICO jurisdiction hangs on the interstate commerce element, and the interstate commerce element is cleanest through the financial fraud theory, and the financial fraud theory requires establishing that the suppression of your investigation was an act in furtherance of the fraud rather than simply a related event. You've been living on the street for 22 months working on this." "Yes." "What does that feel like?" "Like preparing for the most important trial of my career," Daniel says. "With worse accommodations." Maya almost smiles. "I'm going to need 2 weeks to verify the documentary record. If it holds, and I think it holds, I need you to understand that filing this will make both of us targets of the same network you've been documenting. They already did their worst, Daniel says. They did their worst when you had a career and a home, Maya says. What they can do to a federal public defender with an active practice and a family is different. This is your decision, not mine. I'm bringing you a case. Whether to file it is yours. 2 weeks, she says. Come back on Saturday. Bring coffee. Daniel returns on a Saturday with coffee. Maya's expression carries the specific quality of someone who has followed a thread all the way to the end and found something they did not expect. The managing partner, Harrison Wells. I pulled everything I could find on him, and I found something you didn't flag. Daniel is quiet. His charitable giving record. He sits on the board of a foundation called the Zeno Institute. Has for 9 years. I saw the Zeno Institute in the public record. I didn't follow it. I did. The Zeno Institute's primary funding comes from a network of donor-advised funds. The donor-advised funds are connected, through an intermediary structure, to the same beneficial ownership chain as 3 of the entities in your financial fraud map. She pauses. Daniel, the Zeno Institute funds judicial education programs. It funds the training that Cook County judges attend for continuing legal education. It has funded, across 9 years, the professional development activities of every judge on your map. Daniel sits with this. They weren't just buying outcomes, he says. They were building a pipeline that has been systematically placing sympathetic jurists in positions to manage outcomes in cases that touch the financial network for 9 years, using charitable infrastructure that looks entirely legitimate on the surface and that has been, until 2 weeks ago, essentially uninvestigated because nobody had the full map to understand what they were looking at. The RICO case just got larger, he says. The RICO case just got significantly stronger, Maya says, because what we can now show is not just a conspiracy to suppress a single investigation. It's a systematic pattern of institutional corruption that has been operating for 9 years, documented across both the financial records you assembled and the charitable giving records I've verified. We need a federal grand jury, Daniel says. I've been on the phone with the FBI's Public Corruption Unit for 3 days, Maya says. They've been sitting on a parallel investigation into Cook County judicial irregularities for 18 months. They don't have your financial map. We don't have their judicial conduct data. Together we have a case, Daniel says. Together, Maya says, we have a case that is going to be the biggest public corruption prosecution in Illinois history. The federal grand jury proceedings in United States versus Harrison Wells it all began on a Thursday morning that Daniel Avery spends in the federal courthouse, in the hallway outside the grand jury room, because he does not have standing to be inside it, but he's given a 9-hour witness statement to the FBI's Public Corruption Unit that forms a substantial portion of the foundation of what is being presented inside. He is wearing a suit that Maya's office arranged for him, which fits well enough that it does not communicate homelessness. The quality of the work is not in question. The FBI's forensic accountants have spent 3 months with the financial map Daniel built and have found 43 additional entities and 217 additional transactions that his public records only research could not access, but that his framework predicted and their warrant-backed investigation confirmed. The judicial education pipeline that Maya discovered has been expanded through the FBI's investigation to include 2 federal judges whose presence on the map has elevated the case to a level of federal significance that is brought in the Department of Justice's Public Integrity section. He sits in the hallway. He watches the courthouse move around him, the lawyers in their suits, the clerks with their carts, the defendants in their street clothes. And he recognizes from 22 months of watching courthouses from the outside and now again from the inside that the courthouse looks different depending on which side of the institution you're operating from, and that the view from the outside is more complete in certain important ways, because the inside shows you the system's procedures and the outside shows you the system's effects. He has now had both views. He is not sure, sitting in the hallway, which one he will carry forward. The grand jury returns a true bill on 27 counts spanning RICO conspiracy, mail fraud, wire fraud, obstruction of justice, and bribery of public officials. Harrison Wells is arrested on a Tuesday morning at Callaway Mercer Ellis's offices, which is a detail that Daniel learns from Maya's text message at 8:47 a.m. while he is at the McDonald's on Wabash, 2 hours early, waiting for Zoe. She arrives at 10. She's 11 now. She sits across from him with a Happy Meal she does not really want anymore. She is 11. She is past Happy Meals, but she orders one every time because the routine is what the meetings are built on, and she is not ready to change the routine. She says, "Dad, did they arrest him?" "Yes," Daniel says. "Mr. Wells?" "Yes." She looks at him. "Are you okay?" she says. Daniel considers this question with the specific care that Zoe's questions deserve. "I'm getting there," he says. "Where are you sleeping?" she says. "I have a place," he says. "Maya's office helped. It's small, but it's mine. When do you get your license back?" "I've applied. It takes time. Will they give it back?" "I think so." Zoe considers this with the quiet patience of someone who has been waiting for a long time and knows that waiting is sometimes what is required. "Good," she says. "I want you to be a lawyer again." "Why?" Daniel says, genuinely curious. "Because," Zoe says, "you're good at it. And the people who need lawyers don't always have them. And you're not like that." She pauses. "You're like the other kind." "What other kind?" "The kind who remembers what it's like," she says, "when you don't have one." 7 months after the grand jury returns its true bill, Daniel Avery's law license is reinstated by the Illinois State Bar Association, in a proceeding that the bar's disciplinary board describes as a complete exoneration of the underlying conduct, 4 words that Daniel reads 3 times in the formal letter. Not because he needs to read them more than once to understand them, but because they're the specific 4 words he has been assembling evidence to produce for 22 months, and he wants to give them the weight they have earned. He does not return to private practice. He takes a position with the Federal Public Defender's Office, Maya's office, because the conversation about why he should be in public defense rather than returning to partnership track has ended each time he and Maya have had it, with Daniel more certain that the view from outside the cooperative side of the institution is the view he wants to keep. He passes the bench on Mercer Street on his way to the federal courthouse. Every day, because Mercer Street is on the route and he has not changed the route, partly from habit and partly from the specific, deliberate decision of someone who has decided that the view from outside the cooperative side of the institution is information rather than embarrassment. The bench is occupied, some mornings, by a man he does not know. On those mornings he stops. He gives them a number for the city's legal aid line. On the specific mornings when he can see in the person what he had learned across 22 months to recognize the quality of someone who is in an impossible situation and is thinking rather than just surviving in it, he gives them also a card with his office number. He is not trying to save anyone. He is a lawyer, not a social worker. He is trying to be, as Zoe said at the McDonald's on Wabash, the other kind, the kind who remembers what it's like. The kind who, when he sits across from a client in an orange jumpsuit with 21 minutes of the system's allocated attention, gives them the full weight of what he has built across the years of his career, which includes the 16 years of partnership track and the 22 months of the bench, both of which are part of the education. The most important trial of his career is not the grand jury proceeding, which he was not in the room for, or the subsequent criminal trial, which ended in convictions on 19 of 27 counts. The most important trial of his career is the one he will walk into this morning at 9 a.m. on behalf of a client who has been waiting 11 months for a trial date and who has, until Daniel was assigned to the case 3 weeks ago, had 11 minutes of attorney FaceTime with anyone from the public defender's office. He handles them as if each one is the most important case he has ever tried, which is something 22 months on the street taught him and which he does not expect the institution to teach anyone else. Harrison Wells was convicted on 19 of 27 counts and sentenced to 23 years. The 3 Cook County judges were removed from the bench. The state's attorney resigned the day before the grand jury's true bill and is cooperating. The Zeno Institute surrendered its nonprofit status. Maya Chun was appointed to a federal district judgeship 18 months after the case concluded. Zoe is 12. She still has opinions about Sarah. The Art Institute has Saturday hours. He takes her when he can. He walks past the bench on Mercer Street. He adjusts his bag. He goes to work.